Hi, I'm Mike Winkler, and I'm the Principal Managing Broker for Coldwell Banker Bain in Issaquah, Washington.
And I'm E.J. Bolts. I'm the Principal Managing Broker for Coldwell Banker Bain on Mercer Island, Washington.
E.J., in our last Realty Bros blog post, we talked about the broker development series, of which a section is purchase and sale contracts. And one of the reasons we focus so heavily on purchase and sale is because it really is the canvas which enables us to demonstrate our art and skill in negotiations and contracts.
That's true.
Unfortunately, there's a shifting kind of landscape to be painted with regards to the market right now.
That's right. One of the things that we deal with is that as brokers in the state of Washington, we deal with a standardized set of contracts that have been produced by the Northwest Multiple Listing Service. We've done an earlier Realty Brothers blog post on the Northwest Multiple in terms of its importance.
I'm only laughing because this is real life. We just had the vacuum cleaner come on with the custodial service. So anyway, go ahead.
Anyway, it does make sense that the contracts used in the complex real estate sales process are standardized, because what it allows everybody to do is to know the rules, know the time frames, sort of know the rules of engagements. And it also allows the brokers to help buyers and sellers put deals together without practicing law in actually writing the contract form itself.
Well, in fact, our forms were most recently major overhauled in terms of a statewide basis only a couple years ago.
That's right.
And yet we find ourselves, because of 4 areas where changes occur on a regular basis and what we'll coin as non-standardized contracts are kind of showing up.
Inserted into the process.
Inserted into the process. And that begins with addenda from builders, which isn't uncommon, and we've seen it before, but some of the builder addendums, because financing is so challenging for builders now, are more onerous than they have been in the past, with much higher per diem rates for failure to close on the proposed time in the contract, and changing terms with regards to when the waiver of financing can occur, or in fact making it occur when otherwise it might not. And so those kinds of things are challenging, as long as they're challenging in themselves, but if you know they're there, you can deal with them. Lenders have changed their contracts with regards to how short sale properties are sold. Relocation companies are often inserting their addenda, and I reviewed a contract the other day, was 73 pages long. That was a relocation contract, and that was, talk about a non-standard contract. It was enormous. And then non-standard contracts with regards to banks and their REOs, or bank-owned properties.
That's right. The builder addenda we've seen for many years, as Mike has said. There have been some twists added lately, as he mentioned. But generally, a builder addendum will deal with the items dealing with the construction itself, in terms of how you might pick building materials, when you might be able to make changes based on when the construction is, and it does deal with financing. And we have found that they normally deal with the same items, and with a quick attorney review, we find that we can move ahead fairly easily with the builder addenda. The relocation addenda are a similar vein, in that we see a lot of them, and we have over the years, and they almost always deal with the same topics. So once again, we actually get a familiarity with many of the addenda from the relocation companies, and we're able to work through with adequate attorney review, as always, but oftentimes as principal brokers, we've seen the same form enough that we can give a good counsel to our agents and our clients.
Well, short sale, and especially REO addenda, are relatively new because they're used on a national level, and so by large lending institutions. And one of the challenges is that we are seeing national contracts that will have exceptions. Well, not in this state, and you kind of see that in offerings a lot of times in terms of consumer products or financing products. The problem is that many of those contracts violate Washington state law, and a broker could, through either ignorance, inexperience, or just inattention, cause harm to their client by allowing a clause. For example, one of the most recent ones we've seen is earnest money to be held out of state.
Yeah.
And well, that's not proper or legal in the state of Washington, and it could put the earnest money at risk. On the other hand, the heavy hand of the lender is, do you want to buy my house? Now remember, an REO is a bank-owned property as a result of a foreclosure. And often buyers are enamored by them because they can be presumed as really great deals in this market. But again, you know, the bank is asking you to give up rights and to warrant certain circumstances with the house that you wouldn't normally have to do in a traditional transaction. So they have to be looked at very carefully, don't they?
Yeah, they do, and we oftentimes would have an attorney or advise our client to have an attorney look at those addenda, but the client won't always do that. I mean, that's the bottom line on it. The banks also, in the REO contracts, sometimes leave themselves a way out. They say that they can basically terminate the contract right up till closing. Sometimes it has to do with some a possibility of some sort of a redemption from an earlier owner, which very rarely happens, but the bank needs to leave that possibility open for themselves. And so basically, with all of these different non-standard forms, with attorney review, we can deal with virtually all of those. And we can never really get away from actually needing some non-standard forms in certain contracts, because every contract is different, every home is different, every property is different, and every situation is different. So standardized contracts really can't, sort of by definition, handle every possibility that comes up.
Well, and so the lesson for today is really that buyers, sellers, and brokers should always try and use the standardized Northwest MLS forms when possible. In fact, you can receive an offer and you can counter in Northwest MLS forms. Or right. Certainly, if you're representing a buyer, you should begin the process with Northwest MLS forms. But the moral of the story is that if it morphs into a non-standard contract, it's not that you have to be afraid of it, it's that you have to pay extra attention to it to make sure that the normal coverages and exceptions and waivers and contingencies that you want to have in place for your client are intact in some fashion in the contract that's non-standard. Because the bottom line with all of these non-standard contracts is that they always, and it's dangerous to use those types of words, but they always are in favor of whoever is the writer of that contract.
Absolutely. So we do want to make sure that we have proper attorney review when necessary, and that we are protecting our buyers.
And sellers.
That's right. I'm E.J. Bolds.
I'm Mike Winkler. Till next time.